It issued a briefing on the report on 20th June 2022, summarizing the thematic areas therein and disclosing its findings as well as actions taken to remedy the issues identified. It also conducted its annual audit in compliance with Regulations 11 and 12 of the Election Technology Regulations 2017 and a certification of compliance. IEBC relied on sworn affidavits by Michael Ouma, Moses Sunkuri, and Majan Hussein Majan on 26 August 2022, which were to the effect that it published the interim report by KPMG on 8th June 2022 and embarked on remedial measures aimed at effecting the recommendations ahead of publication of the final report. It was ascertained that it could not publish the integrity and security of the electoral technology system, considering the provisions of the Data Protection Act, which imposes a data of Kenyan voters. On the other hand, the first and second respondents urge that even initiate the result of the presidential election. Upon considering all the printing submissions and the ICT scrutiny and inspection tallying and recount report, which fully examined the IEBC's result transmission system, RTS, we are not persuaded by the allegation that the technology deployed by IEBC failed the standard of Article 86A of the Constitution on integrity, verifiability, security, and transparency for the following reasons. 1, whereas it is true that the KIMS kit failed in 235 polling stations, 86,889 voters were granted the right to vote manually, and the requisite forms 32A were duly filed. This happened successfully in Kibwezi West constituency, and Pondit's report was released to the public 7 days before the 9th August election. The register of voters was used at the election without any apparent anomalies. 3, Smartmatic was procured to provide the necessary technological infrastructure, as IEBC did not have the capacity to do so. No credible evidence meeting the requisite standard of proof of access to the system by unauthorized persons was produced by the petitioners. The scrutiny report prepared by the registrar of this court did not reveal any security breaches of the IEBC's RTS. IEBC successfully deployed a biometric voter register system which captures unique features of a voter's facial image, fingerprints, and civil data to register and update vote details across the country and also in the diaspora. The BVR captures a voter's facial image, fingerprint, and civil data which featured 2011, IEBC opened the register of voters for verification of biometric data by members of the public for a period of 30 days. Thereafter, then audited the register, and we are satisfied that the inconsistencies and inaccuracies identified during the audit were somewhat successfully addressed. The second issue was whether there was interference with the uploading and transmission of Forms 34A from the polling station to the IEBC public portal. The first petitioner arranged staging that a person who had access to the RTS intercepted, detained, or stored Forms 34A temporarily to convert or manipulate it before uploading it on IEBC's public portal. It is arranged also on 11th August 2022, IEBC dumped over 11,000 Forms 34A on the public portal between 11 to 11:09 hours. To rebut this allegation, IEBC and its chairperson, in their response dated 26 August 2022, denied staging and unauthorized intrusion of the RTS. In that regard, they urged immediately after the transmittal of results, the form was received as evidence by the timestamp. Similarly, the first respondent denied these allegations. Our finding: 1, no credible evidence was presented to prove that anyone accessed the RTS to intercept, detain, or store Forms 34A temporarily before they were uploaded to the public portal. The allegation that 11,000 Forms 34A were affected by staging was simply not proved. 2, the allegation that IEBC, its officials and strangers used a tool to tamper with the Forms 34A before converting them to the portable document format, that is PDF, that eventually appeared on the public of Justice Nyangaya, shows that the original Forms 34A from the contestant polling stations, which were allegedly intercepted, were exactly the same as those on the public portal, and the certified copies that were presented to this court pursuant to the provisions of Section 12 of this Supreme Court Act 2011. 4, regarding the allegation that the integrity of the public portal was compromised, this was disproved by evidence of consistent attributes such as unique mission of results. 6, the RTS was configured on a virtual platform network, VPN, and the SIM cards locked to a specific polling station. The server was also configured to accept results only from authorized and properly mapped KIMS kits. In our view, the petitioners failed to produce credible evidence to the contrary. 7, in view of some of the logs presented as evidence of staging, showed that they were either from logs arising from the 2017 presidential election or were outright forgeries. In our considered view, there was no evidence of a man-in-the-middle server configured to the IEBC's VPN network, and no evidence was produced to show that the chairperson of IEBC and staff were part of the arranged conspiracy to stage the transmission process. 9, whether there was a difference between Forms 34A uploaded on the IEBC public portal, and the Forms 34A received at the National Tallying Center, and Forms 34A issued to the agents at the polling stations. The Forms 34A, as demonstrated in the affidavits, to the effect that votes were being deducted from the first petitioner and being added to the first respondent. To support this petition, evidence was contained in the affidavits of Honorable Martha Karua, sworn on 21st August 2022, Arnold Ochieng Oginga, and John Mark affidavit sworn on 28th August. Allegation portal were not interfered with or manipulated. Further, that the Forms 34A signed at the polling station and issued to the agents were identical to the Forms 34A uploaded on the public portal and delivered to the National Tallying Center at the Bomas. It was contended that in any event, IEBC used the original physical forms to show election results. This court ordered forms from the 41 polling stations outlined in the affidavit of Celestine Opio to ascertain the allegation of interference. And this is our finding. 1, there were no significant differences captured between the Forms 34A uploaded on the public portal and the physical Forms 34A delivered to Bomas that would have affected the overall outcome of the presidential election. B, no credible evidence was presented to support the allegation that Forms 34A presented to agents differed from those uploaded to the public portal. The report by the registrar of this court confirmed the authenticity of the original forms in the sampled polling stations. The affidavits of Celestine Opio and Arnold Ochieng Oginga, while containing sensational information, were not credible, as the registrar's report confirmed that all the Forms 34A attached to those affidavits and purportedly given to them by the agents at select polling stations were significantly different from the originals, certified copies, and those on the public portal. The purported evidence of Celestine Opio and Arnold Oginga, sworn in their respective affidavits, are not only inadmissible, but are also unacceptable. It has been established that none of the agents on whose behalf the forms were being presented saw any affidavit, that there is nothing to show that they had instructed both Celestine and Arnold to act for them. Yet the two have gone ahead to depone on matters that are not within their knowledge. This court cannot countenance this type of conduct on the part of counsel who are officers of the court. Though it is elementary learning, it bears repeating that affidavits filed in court must deal only with facts which an opponent can prove of his own knowledge, and as a general rule, counsel are not permitted to swear affidavits on behalf of their clients in contentious matters like the one before us, because they run the risk of unknowingly swearing to falsehood and may also be liable to cross-examination to prove the matters deponed. We must remind counsel who appear before this court, or indeed before any other court or tribunal, of the provisions of sections 1, declaration upon a matter of public concern, and contain no more than incredible and hearsay evidence. No admissible evidence was presented to prove under the direction to show that one Jose Camango accessed the RTS and interfered with the result contained therein. This also turned out to be no more than hot air and we were taken on a wild goose chase that yielded nothing of probative value. The Kim's kit relating to Songonyo Primary School, same serial number with another, was admitted by I as an inadvertent manufacturer's error. We are also satisfied that the two kits had other identifying features that were markedly different, including the stamps and polling code, and therefore South constituency resulted in voter suppression to the of the postponed elections for various seats during the general to IEBC power to postpone elections, county or wards stipulated by the Constitution. The petitioners are content the postponement of elections and the overall effect of suppressing voter turnout in the electoral units in question with the printed ballot papers, and that they only discovered the mix-up on the eve of ballot papers can only be opened on the print and replace the ballot papers in time for the elections. For this claim to succeed, it must be demonstrated first, IEBC and no authority in law to postpone the elections, and that the postponement was deliberate and calculated to suppress voter turnout so as to affect the result by reduced Elections Act, which provides for circumstances when elections can be postponed in a particular election. Been more was undertaken. In the empirical data, we cannot find a basis of as a matter of fact or evidence, since the that there was systemic ballot stuffing in certain counties, mainly in the Rift Valley and central parts of Kenya, where, according to him, a total of 30 person, while acknowledging that and for other positions, but did not take part in other elective positions. The differential also includes rejected ballot papers and stray votes, which do not count as the votes. The well-established principle that to demonstrate that there were instances of ballot stuffing of such a magnitude as to justify the execution of the presidential election. Ballot stuffing, which is an illegal addition of extra ballots, is a type of electoral fraud aimed at swinging the results of an election towards a particular direction. With a single document, without more, it's an offense, and it must be end of the Elections from Offences Act. It is indeed that not affect the house for a person to vote more than one in any election. IEBC has profound and plausible explanation for the vote differential, citing categories of voters who only vote for. There were an insignificant number of stray votes whose combined effect cannot justify nullification of the election. Finally, on this point, a general election in Kenya comprises of 6 different separate elections held concurrently on the same day. Such elections are held by secret ballots, and one cannot predetermine the voter turnout or how voters will vote in each election. None of the parties has flagged anything so significant that it would have affected the outcome of the presidential election vis-a-vis the other 5 elections held on the same day. We find, therefore, there were no unexplainable other elective positions. On issue number 6, whether IEBC carried out the verification, tallying, and declaration of results in accordance with Article 138, 3C, and 110 of the Constitution. This issue arises from the printings in all the petitions as consolidated. Based on the said printings, the affidavits will support thereof and the written and oral submissions by parties, two viewpoints regarding the meaning, scope, and absence. The role of verifying and tallying of votes as received from polling stations countrywide is vested in the Commission as a corporate entity and not the chairperson of the Commission. It is their argument that the chairperson cannot undertake this task to the exclusion of other commissioners. They submit that the language of Article 138(3)(c) does not envisage a situation where the chairperson can. The language of Article 138(3)(c) does not envisage a situation where the chairperson can arrogate to himself unfettered authority to verify and tally the results at the National Tallying Center without involving the other commissioners. Such action, they contend, would not only be unconstitutional, but would be sufficient ground without more to nullify an election of a president-elect. In support of their argument, the petitioners cite the Court of Appeal decision in IEBC versus Maina Kiai and Fine. The petitioners further submit that Regulation 87(3) of the Election General Regulations is unconstitutional. Verification and tallying in the chairperson of IEBC. Of a presidential election at the National Tallying Center is the exclusive preserve of the chairperson of IEBC. According to them, there is nothing unconstitutional about Regulation 87(3) of the Elections General Regulations. The same regulation the respondent submits makes no mention of commissioners other than the chairperson. At any rate, the respondents argue Article 138(3)(c) of the Constitution does not envisage a situation where it is the commissioners who personally undertake the task of verifying and tallying the results as entered into the thousands of Forms 34A. Such an undertaking would be humanly impossible, they submit. For good measure, the respondents submit that Section 11A of the IEBC Act provides that the chairperson and members of the commission are responsible for the formulation of policy and strategy of the commission and oversight in election results. The task of verifying, as stated by the respondent, is executed by the staff of the commission under the direction and supervision of the commission secretary, who in turn of the commission secretary, who in turn reports to the chairperson. The chairperson acts as usual. Having done so, the petitioner states that the chair to conduct the verification and tallying process, the commissioners, each of he assigned verifiable roles and related to the verification and tallying exercise. On his part, the chairperson of IEBC submitted that although he has the exclusive authority to verify and tally the presidential election results, as the commissioners in the exercise before eventually declaring the filing that the National Tallying Center vests not in the chairperson of IEBC, but in the commission itself. The latter carries out this exercise through its secretariat staff, technical personnel, and any other persons hired for that purpose under the oversight another versus INDC and 2 others, as reported in 2017 Kenya Law Report, popularly known as Raila 2017, and appeal decision in BC versus Maina Kiai. We also find that the chairperson cannot arrogate to himself power to verify and tally the results of a presidential election to the exclusion of other members of the commission. He did Article 138(10), and in the chairperson, he does so only as a delegate of the commission. Consequently, to the extent that Regulation 87(3) of the Elections General Regulation on the chairperson to the exclusion of other members of the commission, the same is contrary to and inconsistent with the. That said, we, however, take cognizance of the fact that the NAS actively participated in the application for the declaration of the result by the chairperson. They took turns adding at Bomas. An example is when one of Nyangaya stood on the podium to the public results and also announced an adjustment that had been occasioned by errors of tabulation. The events of 15th August 2022, therefore, came as a surprise. As the public waited for the chairperson of IEBC to declare the final results, sporadic violence broke out at Bomas. The violence swiftly was contained by the security forces, but there was unexpected drama as 2 different factions of the commission began to emerge. Kenyans found themselves watching an appalling split-screen scenario on their television sets. On one part of the screen was the chairperson reading himself to declare the results in accordance with Article 138(10) of the Constitution. On the other part of the screen were the 4 commissioners on the runs of the Serena Hotel, Nairobi, from where they announced that they would not own the results that were soon to be declared by their chairperson. The 4 commissioners informed the public of their rejection of the yet-to-be-announced results, terming them opaque due to the manner in which the chairperson had been conducting the verification and tallying exercise. In his affidavit dated 25th August 2022, Justice Nyangaya affirmed that the chairperson's actions during the tallying and verification exercise at Bomas made it difficult to ascertain the total number of votes cast and the actual number of votes attained by each candidate, so as to enable him authoritatively state the commission and accurate results. All the petitioners have arguments for the nullification of the 9th August presidential election in Taharia on the walkout from the Bomas by the 4 commissioners. They contend that by rejecting IEBC's results on ground, they further submitted that being in the majority out of the 7-member commission, their view should prevail and the election should be nullified. It is the petitioner's argument, therefore, that a dysfunctional cannot deliver a credible election. We note that apart from their 11th hours, have not placed before this court any information or documents showing that the elections were either compromised or that the result would have substantially differed from that declared by the chairperson. They have not explained why they participated in a verification process when they knew that it was opaque up until the last minute. Indeed, the person on his part did not make matters any better, even as they to be falling apart. Point institution entrusted with one of the monumental tasks of reforms, of which we shall say more in our detailed reasons. Nullify an election on victory between the chairperson of the commission and some of its members. In the absence of any evidence of violation of the Constitution and our electoral laws, how can we upset an election in which the people have participated without interest of IEBC? The Commission impugns the state of its corporate governance that does not affect the conduct of the 2022 election. In view of the foregoing, understanding the divisions apparent between the chairperson and the 4 commissioners, IEBC carried out the verification of the Constitution. Issue number 7, provided by Article 138(4)(a) of the Constitution. They anchored their claims on the basis that in order to determine whether a candidate has attained 50% plus 1, in their view, were the variant votes cast, which amounted to 7,176,582, supporting the claim that the first respondent did not meet the 50 plus 1 constitutional threshold was the 6th petitioner. His contention was founded on the backdrop of a press briefing issued by the chairperson of IEBC after the 0.4% of the total number of registered votes based on the verification of the KIMS kits, which were functional and did not include some 238 polling stations where the KIMS kit had malfunctioned. Urged that the minimum number of votes cast could not be less than 14,466,779. Additionally, the manual register were included. The 6th petitioner further claimed that a summation of the minimum number of votes cast and manual votes would 113,640 computed this number by subtracting 14,326,641 declared votes cast from 14,466,779 generated by the 6th petition as representing 65.4% of the voter turnout. Referring to the from 34C, the 6th petitioner summed the number of votes cast for each candidate as follows: 9,176,141, Wahiga Mwaura, that 1,987. William Ruto, according to him, garnered for 99%, 8.3%, 1.22, and Constitution identified as having voted on the KIMS kit, that the final voter turnout comprising of the voters who were identified through the KIMS kit and those who voted manually was 64.76% and not 65.4% as arranged by the petitioners. Announcement by the chairperson of evidence of this correction was provided to the malfunctioned in 235 polling stations. Backup KIMS kits were later deployed results to this issue. It must be restated that the case made by the 6 petitioners data-specific threshold as enunciated under Article 184 of. In our view, the assertion by the sixth petitioner that given by the chair